Ready, clock? That time when we start for you, you'll have 10 minutes when we start.
There's absolutely no way to rebut a 35-page report in 10 minutes. I think that's outrageous. Let's start with celebrating democracy.
Yeah.
Thank you. Thank you to those who stayed here till 1:15 in the morning on September 26th. To the Board of Supervisors, you have a job to do. You do not have to follow the advice of your township engineer or your solicitor if they're wrong. And they are wrong. A 1.2 million square foot warehouse without a use is based on speculation. When I have conditional use cases or special exception, my clients get criticized because all they do is present testimony that's speculative and doesn't follow the law. Guess what? A speculative warehouse doesn't follow your zoning ordinance. Your zoning ordinance requires them to identify the use. What if they're wrong? What if it's Amazon? How many of those little trucks are going to come in and out? How many times a day? How many 18-wheelers are going to come down, rolling down the road with merchandise to fulfill our e-commerce needs? Let's talk about e-commerce. In West Hempfield Township, the former QVC warehouse closed and was taken over by a company named Saudia. Saudia said, we need to expand our operation, we need to rezone the next door neighbor property because we're going to employ 1,000 people. 3 years later, 100 employees, and they're going bankrupt. Warehouses around the area are vacant. Companies can't fulfill the warehouse requirements. These people work on speculation. Your engineer, who's not a lawyer, although he appears to be practicing, says, it is my understanding that case law, now I don't know why an engineer is talking about case law, that's not his job. It's my understanding that case law has deemed generic warehousing approval not only a valid exercise of supervisor power, but that such approvals are required by law. The solicitor didn't bother to put a footnote on that one. That's not an accurate statement of law. That's the illegal practice of law by the township engineer. Let's talk about speculation. You know, in Mount Joy Township, I faced the same developer. He proposed a 1 million square foot warehouse before the zoning hearing board based on speculation. They lost. Newberry Township, York County, 300,000 square foot based on speculation. Same traffic company, same traffic engineer. The board determined the traffic engineer wasn't credible. Plan denied for a speculative warehouse. You know, September 26th, I had a much different 10-minute presentation. But at 2:45 in the afternoon yesterday, I got an email from the solicitor attaching a 35-page response to my expert reports. To say my experts were upset would be an understatement. The number of misrepresentations, failure to accurately cite their report and testimony, and their erroneous conclusions, and not give us a chance to rebut, is another example of the lack of transparency by this body. But you did post it on your website. Thank you. That's the first document you have posted on the website, notwithstanding emails telling me documents are on the website. There are no documents on that website. Did you post my engineer's report? Did you let the public read what they had to write? No. Why is that? Why does the staff let down the citizens. The board should know better and do better, and I hope you do better. Let's talk about the law. 508 of the Municipalities Planning Code requires you to approve this plan if they meet the objective criteria. If they do not meet the criteria, you have a duty to deny. It can be for one reason. There is case law that says one valid reason for failure to comply with a specific provision of the zoning ordinance is sufficient and has been upheld on appeal to the Commonwealth Court. The burden, they have the burden, not us. They had the burden to prove that they meet the requirements of the ordinance. I submit they ain't done that. What is the role of the Board of Supervisors tonight? It's the function of the board to determine whether the evidence satisfies the criteria for denying the application. You are the fact finder, not the solicitor, not the engineer. You are the fact finder. The board has the exclusive authority to determine matters of witness credibility and weight. And Mr. Linker, you actually said that. You said that correctly at the last hearing. When I was challenging the qualifications of the expert witnesses, you are correct. It's up to the board to determine the weight. And you should give no weight to Mr. Holtzman's testimony about noise or pollution because he wasn't qualified to testify. No weight to the testimony of noise or pollution. By the way, this no-rise study, there's a July 30 version. I was told July 9 was the final version. I have an email from the solicitor saying the staff told him July 9 was the final version. Why did the staff lie to the solicitor? I don't understand that. What motive does the staff have to misrepresent information to the solicitor? I'm going to assume my time is short. I got a lot to say. I'm going to give you the reason and the basis to deny the application. Section 304.24.e. Quote, the applicant shall furnish expert evidence that the proposed use will not be detrimental to the use of adjoining properties due to hours of operation, noise, light, litter, dust, and pollution. I thought it was pretty clear. They had nobody testify. You requested a hearing. You wanted to hear from the experts. But we weren't allowed to challenge the qualification. We let them testify. And we're treating it like a public hearing. It was expert evidence. That's what they were supposed to produce. They didn't produce it. Not a single report was provided by the applicant at that hearing. They didn't treat you with respect. And now we have page 17 of your 35-page document. Here's what the Township engineer said in response to 304.24e that required expert evidence. Expert evidence. That's not a defined term in your ordinance. There's no cases cited by the engineer or the solicitor on what is expert evidence. The engineer says many of these items are addressed disparately throughout his submission. Okay. For example, lights will be directional LEDs outfitted with hoods to reduce glare. Okay, residents who live next door that are worried about the cars and the lights from the cars and the trucks shining on your property, will the LED lights that are shielded from glare stop those traffic lights from shining into your property, into your backyards?
No.
Dust pollution and noise are not anticipated to be worse than other standard warehouse uses. Did they provide any information on other standard warehouse warehouse uses? Did they give you a technical basis to compare? Did they do a noise study? Answer, no. There's no noise study. Whether these constitute enough expert evidence to determine whether the use will be detrimental or not is likely a legal and policy question that I, the engineer, cannot respond to, as there are no technical-based criteria for me to judge the ordinance provision on. Further consultation should be sought from the township solicitor. Here's what the township solicitor wrote in a footnote. 304.24E does not require expert testimony. There would not normally be testimony in a land development plan consideration. That's true, but you asked for a hearing, and you had the power under the township code to ask for it. You asked for it, and you got it, and we thank you for it. The section requires, quote, expert evidence which may be in the form of a plan submission as summarized by the township engineer. This is the line, folks. Lawyers around the state who I've been in touch with today are not pleased. Quote, what was supplied by the applicant is sufficient to meet the requirement of this section. That's not his job. That's your job as the Board of Supervisors. It's not for the lawyer to tell you if they meet a requirement. That's not legal advice. That's policy. Where does expert evidence get defined? Certainly the board can say they want something more because they're not persuaded by what's in the application and would want to ask questions of a live witness who knows what they're talking about. Did you get a chance to answer the question to the no-rise study person? No. Did you get to ask questions about a noise study? No. Did you get to ask questions about pollution? No. They didn't present qualified witnesses to testify to that. This term of expert evidence is not defined in your ordinance. So the board should take the approach that a mere statement not supported by objective evidence, not subjective speculation opinion, is insufficient to satisfy the standard of expert evidence. That's 304.24E. Did they demonstrate that the proposed use, which we don't know what the proposed use is, by the way, but I'll get to that, will not be detrimental to the use of adjoining properties due to hours of operation, 24/7. What was the evidence that a 24/7 operation will not be adverse to adjoining properties? I didn't hear anything. What I heard was, well, that's just normal generic warehouse operation. No, it's not. The ordinance specifically requires them to address the question. They don't address it.
Attorney Clark, your time is up, although I'm happy to allow
He
you
deserves more.
As long as, sorry.
Give him more time.
I'm sorry. As long as it appears that Attorney Gamble would be satisfied, as long as I assume you have sufficient time, in equal time.
Yes, he can continue for as long as the board would like to entertain his argument. I don't see a reason to cut him off.
Okay, thank you.
By the way, we just had the Jewish New Year, and we're about to have the Day of Atonement. David is up against Goliath.
Yeah.
We've got the largest warehouse developer in the country.
Yeah.
Good person, I think he's a Penn Stater. God bless him. McNeese Wallace, the largest law firm in Harrisburg. Tremendous law firm. Some of my really good friends work there, and I respect them, even though there's no joy in Mudville tonight because the Phillies lost. And we have the solicitor who's got his own law firm. We are up against massive resources. Your township engineer is from the largest engineering firm. In fact, when I chaired the board of the Harrisburg Authority, that's who I relied upon, because HRG is the best. But not this time. Let's talk about traffic. The modeling of a zoning use warehouse as Land Use Code 150 is a statewide standard required by PennDOT in the majority of traffic impact studies. What's the citation to that? Where's that statewide standard published? You heard Mr. Nahn's testimony. He talked about Land Use Code 150. I don't believe the township engineer properly responded to his comments. The first thing I want to note, what is the proposed use of this property? Let's go back to March of 2022, when Greg Holtzman presented the concept plan for a warehouse at 401 Mulberry to the Planning Commission. There were two concept plans, warehouse and manufacturing or warehouse and storage. But Mr. Holtzman, he wasn't sure when he was contracted to work on the project, because Attorney Gemmell said they didn't get involved until March of 2023. February 26th of 2023, the Cumberland County Economic Development Corporation sent out a mass email to officials of every municipality within Cumberland County. Heads up, quote, we are seeking an approximate 100-acre site, and we may have, the facility in question has to accommodate a food-related, higher-level, automated internal distribution network. Mr. Palmer, what happened to that proposal? One day later, you identified the site. You said the 100-acre Yorklitz property is the site we want for this. And in fact, in March, Panattoni went under contract for that site for a generic warehouse. What happened to the food use? Did you follow up? Do you know it's actually going to be for food-related, higher-level automated? My traffic engineer tells me, well, gee, if that's the fact, Land Use Code 150 is not valid. It's a fulfillment center. It's 155 or 157. Triple the amount of trips. If in fact they know this is the food-related, higher-level, automated internal distribution network for which they were looking for a site in February 26th, and then in March, it's under contract. I don't know. Maybe it's just a coincidence. I would also note, as a sidetrack, this Clomar F thing, I don't want to get into a back and forth. We would certainly like the opportunity to meet with the engineer and review his responses, because he fails to accurately cite Mr. Hayes' comments. He paraphrases. He gets his point wrong. I have so many notes from Bruce Hank today, who was up all night trying to review this 35-page document. But here's the only thing I have to say. Ray Palmer, as the township manager, is not the floodplain administrator authorized to sign this community acknowledgement form. The Board of Supervisors enacted a specific ordinance regarding the township engineer's power. Nowhere does it say he's the floodplain administrator. And you know what your floodplain ordinance says that you adopted in July of 2023? The zoning officer. The zoning officer is the floodplain administrator, and if it's vacant, then the lead land development person fills the vacancy. I don't think Mr. Maldonado signed that form. Somehow somebody determined Ray Palmer fills a vacancy. The board didn't vote on it, and I don't know where he got the power to do that. The solicitor sent me an email that said he has the power to do that. Okay, we'll find out, because I think the board should have a separate vote, separate from the land development plan, to say to FEMA, we withdraw the community acknowledgement form. It no longer represents the view of the community with respect to the floodplain. We request that FEMA reverse its opinion because we're no longer supporting, as the community, a form signed by someone with no authorization to sign it. You can do that separately. You can do that separately.
I just want to address one thing, to allow you the opportunity to respond. That section of the ordinance does state that the zoning officer may delegate that authority, number one, so it's not only the zoning officer.
Where's the evidence of that?
The ordinance says that.
No, where's the evidence of the delegation? How and when did that happen?
Right, that's one issue I'm just trying to address. The second is, and I'll get back to that. The second is that the township structure, as I think I relayed to you in that email, is such that Mr. Palmer manages the staff and steps into that role as the township is structured. That's the way the township is simply structured. So he's the lead of that department at that point. Okay. I just wanted to correct those two issues. If there was a discussion between the township manager and the zoning officer to delegate, that may have been one of the options they may have used.
With all due respect, solicitor, that's not the law. You're wrong. There's no evidence. Your ordinance specifically says the zoning officer is the floodplain administrator, and yes, that person can delegate, but there's no evidence anywhere of the delegation. There's a specific person identified if there's a vacancy in the zoning officer, but it ain't the township manager. And it doesn't say the person who filled the vacancy then has the power to delegate. But that's a side issue. Let's talk about traffic scoping, and I'll try to conclude with this point. Land use codes are decided at traffic scoping meetings and reviews ahead of the traffic impact study submission. This is a review comment by the township engineer who said there's no explanation. Excuse me, my expert said there's no explanation in the traffic study regarding the proposed land use code 150. They don't justify it. And in fact, the township engineer didn't understand where my expert got his figures on the number of parking spaces. I will state for the record, the number of parking spaces came from the applicant's truck turning movement document. 528. That's the number my expert used. That they made a comment, they don't know where he got the number from. What's that tell you about credibility? But let's keep going here. In these scoping meetings, which included PennDOT representatives, they just represented in a 35-page document to the world on the website, there were scoping meetings that were attended by PennDOT representatives. Where are the minutes? Look at the 492-page traffic impact study. It only included the HRG 2 comment letters on scoping. Nowhere does it say there was a meeting to discuss land use codes. More importantly, PennDOT isn't involved because Texaco Road is not a state highway. There's no evidence in the traffic impact study that there were scoping meetings because normally in a traffic impact study, in the appendix, you include the minutes of the scoping meeting. It ain't there. Why? Because it didn't happen. The township engineer made a unilateral decision to adopt Land Use Code 150. There's no PennDOT involvement. If in fact I'm correct, your engineer is lying to you, and you can't have that. You can't rely on that expertise. If in fact you're wrong, Mr. Nahn, in his report, said the lot does not have adequate public road frontage. Township engineer's response, this is true. So what does that mean? What does it mean that they don't have adequate public road frontage? Is that a public safety issue? Is that an issue for pedestrians? Is that an issue for bicyclists? Is that an issue for children walking to school? What about senior citizens out for exercise? If you don't have adequate public road frontage, can I cite you a specific provision of the ordinance? No. But I can tell you this is adverse to public health and safety. And you have to protect public health and safety. I could do a half an hour on stormwater. I ain't gonna bother. I think the point I want to make, and I want you to understand, and it would help if I had an outline. I told you about 30424.e. They didn't have expert evidence on noise and pollution. Let's talk about pollution. All they said in their submittal was that DEP and EPA don't regulate air pollution from mobile sources. True. But one of your constituents sent to you a study on air pollution from warehouses and air pollution from trucking operations. They don't address it. They don't address it at all. Air pollution from mobile sources, it's not a question of whether they need a permit. It's a question of what's the impact on the public health and safety, on the children, and on the senior citizens. When we talk about pollution, it's not just air pollution, it's the pollution associated with trucking operations. They're going to have street sweeping. That's their proposed pollution prevention plan. And in fact, the engineer said, you may want to consider a condition that has them upgrade their pollution prevention plan. They don't address hydraulic fluid, they don't address oil spills, they don't address anything that happens from trucks that are parked and things happen. Drips occur. Where does it go? It runs off the lot. Where does it run off the lot? Into the wetland, into the exceptional value wetland. But the engineer says, we don't regulate wetlands, that's up to the Army Corps of Engineers. Wrong. You can't have a discharge into the wetlands, especially an exceptional value wetland. Lastly, 304.24H. So I'm giving you two specific provisions they are not in compliance with. 304.24E, 304.24H. The applicant shall provide a detailed description of the proposed use in each of the following topics, and you can read the orders for yourself. The solicitor opined that the April 5 comment response document is sufficient. That ain't his job. You know better than that. It's not his job to determine if a submittal by BL companies in response to comments over how are you meeting this standard, he can't conclude they meet the standard. That's not his job. Your job as the board is to determine credibility of witnesses and do fact-finding. And with that, I close by saying, please, you have to reject this speculative application.
We need to hit all of the potential areas of denial. And I think I picked up everything. You suggested that, and maybe you didn't mean, maybe you meant this rhetorically more so, that the board could deny it based on a protection of public health and safety. Is there law that you can cite on that?
Not in front of me. If you'd like me to submit a brief, I would like to do that. I didn't have an opportunity to respond to a 35-page document.
Sure.
The reality is the substantive provisions, 304.24E and H, they don't meet that. The rest of it's gravy.
I cited a case in the footnote, and I appreciate you didn't have enough time to fully respond.
I know, I was supposed to get it Monday morning, what happened?
That was not a communication from me, so I'm not sure.
That was a communication to my clients from somebody on the board that said, we're supposed to have this Monday.
Okay.
2:45,
Right.
Tuesday afternoon
I was
is
not part of that
insufficient.
communication. I don't know if you want us to spend time going back and forth on this, but I wasn't part of that communication, so you had that. I understand you didn't have enough time on it. If you wanted to provide some case law on that, certainly, I'll consider that in support of any decision the board would make.
When the board denies the application, I will assist you in defending the appeal, because you're not going to
Attorney Gamble, Attorney Clark took an additional 18 minutes, so if you would like to take 28 minutes, you may.
I don't believe that will be necessary. I appreciate the time that this board has put into this already and the time that the members of the community have also put into this evening. My name is Helen Gemmel and I am counsel for the applicant. I want to start by reiterating a few things that I know that you already know, but I think they are important. Property owners in this country, in this state, and in this township have a fundamental right to possess and lawfully use their own property. Municipalities may place restrictions on the use of private property, but only when they are intended and necessary to protect the health, safety, and welfare of the community. But to do that, as a matter of law, your ordinance can only implement those health, safety, and welfare requirements by putting in place objective criteria. And that's so that a property owner knows what they can and cannot lawfully do with their property. You can't have an ordinance that says that you have to have a setback that doesn't bother your neighbor. How is a property owner supposed to know what that is? So your ordinance puts in objective criteria, setback in the side yard has to be 20 feet, whatever it is. That is how you fulfill your health, safety, welfare obligations, by objective criteria. A plan cannot be denied for subjective criteria under your ordinance. If a proposed plan for use of property meets the objective criteria of your ordinance, as a matter of law, the township must approve the plan. And I know that's not what the people in this room want to hear, but that's what the law says. And here we have a by right plan. The township zoning ordinance allows this use in this general industrial zone. And I appreciate that there are other uses that are also allowed in this zone, but again, the property owner is entitled to choose the use that your ordinances allow a property to be used for. Your staff, who know your ordinances probably better than anyone else, have provided comment on the plan. And acting in good faith, they allowed the property owner to respond to those things. It's the exchange that happens in order to address the requirements of your ordinance to make sure that a plan does comply. And that was done here. The result was a clean comment letter. Each and every objective criteria of your ordinance has been met for this by right use. Your engineer also went through the expert reports and did not find the assertion of any objective requirement that the plan does not meet. Nothing in this record justifies undermining your consultants and your engineers' independent diligence or conclusions. A township also cannot deny a plan because you disagree with the decisions that are made by outside agencies. I understand that you may not agree with what FEMA has done with respect to its determination and its location of the floodplain. But those agencies regulate items such as erosion and floodplain location and stormwater and water quality. This plan has all those appropriate approvals. Now, when we were talking about my closing argument earlier, what the board wanted to hear, the township solicitor specifically asked me to address the waiver requirements. And we heard during the public hearing that was held on September 26th, the objectors asserted that you have to have an undue hardship in order to grant a waiver. That's not what your ordinance says. Your ordinance allows, in fact, indeed requires, under Pennsylvania law, a grant of a waiver if the requirement is unreasonable as applied to a particular property, or if an alternative standard is provided in the proposed plan that equals or betters what your ordinance is seeking to achieve. And that's what we have here. There are 6 waivers that relate to a separate preliminary plan, the plan size, the minimum radius for access drives, the basin bottoms location below the 100-year floodplain, stormwater pipe size, and maximum gutter flow. If you look back through the reports and the comment letters and what was said, each of those is either doesn't apply to this particular project, or the proposal plan has an equal or better requirement in it. And for those reasons, we believe, as a matter of law, you're required to also grant those waivers. I do want to talk briefly about the role of elected municipal authorities and officials such as yourselves. Not an easy job, but you must follow the law. The ordinances that this board itself has adopted, state law and federal law. And if you choose to ignore the law, then the rule of law no longer has any applicability in Silver Spring Township. Your obligation is to determine what is in the best interest of the township as a whole. All of your approximately 21,000 residents. And there has certainly been criticism of this board with respect to the zoning of this property for industrial use. Again, as a matter of law, a zoning ordinance cannot exclude legitimate uses. Presumably, this board made its determination based on proximity to other industrial uses. But your obligation is not just to one area of residence, but to the entire township. Because your obligation is to the entire township, I urge you to focus on the financial impact of whatever decision you make. You have the opportunity here to accept the proposed conditions of approval that mitigate negative effects and provide positive benefits to this township. And again, I hear the audience jeering behind me. As I sat quietly, I think I was called a sphinx at one point, but as I sat quietly and allowed them to speak. That's the decision this board has to make. You have to think about what happens if you grant the plan, approve the plan with conditions, and what happens if you deny the plan. I know that you have thoughtfully listened to all of your residents who spoke on September 26th, who came out again tonight, who spoke at your other meetings, and I know they've expressed their opinions to you in other ways by submission of information. I know that you have listened to what the attorney and the experts hired by some of your residents have said, And you've taken the time to have your engineer dig through their position to see what merit, if any, it has. And I know that you have listened to the advice and expertise of your own consultants, your engineer, and your attorneys. I know it is not easy to make a decision that your residents who are sitting in this very room very strongly oppose. I understand that not a single person stood up here tonight to support the rights of a property owner other than their own properties. And I appreciate that they are here to advocate for their interests. But this is not a legislative decision. This is a decision as to whether a proposed plan meets the objective requirements of your ordinance. And I understand, now I'm responding to the comments behind me, but there is not a single objective requirement that this plan does not meet. And I ask you to follow the rule of law and approve the plan. Thank you.
Attorney Gilmore, you can take the questions from your seat. I have a couple questions before the board would deliberate. Fair statement that the board would be the final say on comments to be provided to the applicant.
The board makes the ultimate decisions. Yes.
And so if they were to determine, for instance, that the use was not clearly enough defined, and I'm going to refer back to the code issue, the 150 versus 154 versus 155 fulfillment centers. You would need to be, the applicant would need to be given the opportunity to respond to that and to perhaps address that issue.
When a board is acting in good faith and believes that there is an objective criteria in an ordinance that has not been met, then the board has a duty to advise the applicant of that so that changes can be made to address that situation. Now here I believe that we provide enough information, and I think that's why even some of our proposed conditions of approval, we're trying to address that situation.
Sure. And so if the board had concern about the definitions of those uses, is your client prepared to address that, perhaps limit the use to those that we may need to more clearly define than the way those codes are defined themselves?
I know that we provided specific proposed conditions, and yes, we are willing to do that. My partner, who has been more focused on these conditions than I have, is now come to sit next to me at the table. But yes, that's one of the things that we want to make sure that we are meeting the requirements of your ordinance with respect to the use and everything else as well.
Okay. Turning to a couple of specific provisions that Attorney Clark addressed under Section 304.24.e and H. If the board were to determine that there was not sufficient expert evidence that it would not be detrimental, that the use would not be detrimental to the use of adjoining properties due to hours of operation, noise, light, litter, dust, and pollution, would your client be prepared to address that comment from the board?
We would certainly want to address that comment from the board. We think that we have provided that expert evidence as part of our submittals. Typically in a land development plan, you don't even have a public hearing at all, which is only for the purpose of providing public comment. We obviously presented the plan and provided evidence from our experts at that time, but we think that we have already provided that sufficient information. But if the board doesn't think we have, again, acting in good faith, the board needs to communicate that to us so that we can provide that additional information to the extent that you are construing that as an objective requirement in your ordinance.
Okay. And then the same question for subsection H in 304.24. That's the detailed description of the proposed use. We referred back to the April 5th, 2024 letter from BL, but if the board were to determine that that was not a sufficient description, would your applicant be, your client be prepared to address that?
We would certainly be prepared to address that. Again, we think that we have provided a sufficient description. Again, this is a warehouse that's being built on speculation, so we can't say specifically what will be there. We can tell you what will not be there, but we can certainly provide additional information if the board believes that that is an objective requirement that we have not met, which had not yet been previously identified in the comment letters.
Thank you.
With that, I just formally announce the closure of the public hearing continuance. We'll go to the board then for deliberation and statements and comments. I think we'll start on my right, Supervisor Brown.
Thank you very much. First of all, I do want to thank the applicant for allowing us to have this hearing. I realize it was not something that you objected to in the beginning, but I appreciate that you allowed us to do that. And I also appreciate that you allowed the continuance so we could have more public comment. I'm sorry, I'm not sure what my voice is doing here. I also wanted to thank Attorney Clark for your efforts. I thought that much of what you spoke was very compelling. I think you represented your clients well. So I wanted to express my appreciation for that. Most of all, for the residents, I absolutely hate why we're here. Absolutely hate it. But I love seeing all of you here. This is the way that local government is supposed to happen. We need your input, we need your participation, and I love to see this. I appreciate all the time that you've spent coming to different meetings and your very passionate letters and emails to us. Thank you. And for those who organized the website, the chronology is just fantastic. I don't know who put that together, but you did a fantastic job of organizing everyone. So I did want to acknowledge that. When I was sworn in as a supervisor in 2020, after serving for 4 years as the land preservation chairperson, I had these visions of saving land from development. As I learned very quickly, it's not quite that easy. I came to understand that the reality is if a parcel is zoned for a certain use, the owner of that parcel wants to sell to a developer, and that developer has a plan that they bring in, and it meets our ordinances, at 99.999, however, % of the time, it's going to be developed. So what I began to focus on was trying to mitigate the impacts of the development on our residents, on our existing businesses. That became my focus. Now, in terms of this plan and mitigation, back in Attorney Clark, I think you said back in March of 2022 that they presented 2 concept plans. I thought it was June. I'm not sure who, but I was at that planning commission meeting when those 2 concept plans were presented, and I specifically stood up and I asked them about using the Eichelberger entrance. I said that this should be used for the entire parcel, or at least for the general industrial use that they're proposing on that part of the parcel. Now, when this plan came back and it was a 1.2 million square foot warehouse this year, I also brought that up again. Now, eventually going to focus on my friend, J.L. Bruner, who's sitting up front. And I'm going to focus on him, but I'm talking to the family. I understand that your family no longer wishes to farm this property. And I can completely understand and can respect that. Farming is a very difficult endeavor, especially when you consider all of the unpredictability of the weather, prices, the markets. It's backbreaking work, planting, harvesting, taking care of livestock, and you don't actually get a huge return for your investment of time in terms of financial. I also know that speaking to a lot of different farmers about preservation, and for many farmers, their land is that asset. They look at their land as their 401k, as their retirement. Again, I can't judge you for that. I understand that. We do have property rights in this country, and I know that that's one of the tenets that our country is built upon. So I'm not going to judge for that. So I'm looking at this plan tonight thinking, I don't know how the vote's going to go, I don't know how everyone's going to vote, but no matter how that happens, I do think that litigation involving this land development plan could go on for years. So my thought to the owners of this property is maybe there are a couple of other options that you can consider. I'm going to suggest a couple things, but I will be honest that there is not going to be the amount of money for either of these options as one would get selling to develop a warehouse on this property. It's not going to come close, but I'm still going to mention it, and maybe it would help, I don't know. The first one, I would be happy to sit down with your family and talk about land preservation. We have a land preservation program in the township. How it works is we buy the development rights from the property owner. I don't know what that would cost when we get an appraisal done. Obviously, with its current zoning, that could be a really high amount. I don't know. But we buy the development rights, and then you still own the property and can sell to another farmer. We now have an incentive program with the land preservation program that could offer some additional money. I'm going to do a very quick PSA, public service announcement here, because it's related. On October 23rd, Board of Supervisors meeting, we are going to have 2 farms on the agenda for approval to preserve them through the County Farmland Preservation Program. That's not unusual. What is unusual is that there will be 2 separate incentive payments voted on by the board at that meeting. This is the first time we're doing this. We're offering separate incentive payments to farmers for preserving their lands. And the reason I bring this up is I would love to see a lot of residents come out. I'm going to talk about it at the beginning of the meeting, explain what it is, what we're trying to do to preserve even more land in Silver Spring Township. And that's really what I'm trying to avoid is more warehouses and more subdivisions. So that's what we're working on. Now back to the family. Looking at JL again. The second option I want to bring up to you, and I don't know if you even consider, but if there's any way that you would consider coming to the township to get this parcel rezoned to R1, to residential. I think this could be a really like I said, I don't know how this works, I don't know if this is possible, but this property is already surrounded by so much residential, and I think it makes much more sense. You can have single-family homes, apartments, townhomes, things that would provide more of a maximize the land that's not constrained by floodplain and streams. We could do a stream restoration project, there could be a riparian buffer, plantings, meadows where there are not houses, perhaps even have some small shops that people could walk to, have a path that runs through the parcel, and maybe even connects to some neighborhoods that are nearby. I just think this would be a beautiful alternative follow that. I mean, there were other things. I'm still trying to figure out how in the world I didn't fight this. Actually, I'm quite disgusted with myself for not having caught this. I do not believe that this should have ever been zoned light and general industrial.
You moved to approve it.
I'm sorry?
You moved to approve it
Yes, you are
in
correct.
January.
That was specifically about the I-81-114 parcel. I know, John, you sent me that email, which I did read. I specifically spoke about that parcel, about changing that zoning. But in my motion to approve the agenda, I did not talk anything about the Urlitz property.
It was part
I'm
of the
saying that I regret what the Urlitz property was zoned at. That was my bad, that's my fault. There's no other way to put it. So I'm not going to, however, compound one mistake by making other mistakes. So I will be voting to deny this.
Good evening. Thank you for coming. Thank you for your interest. Thank you for all the letters. We heard you. I made some notes this afternoon in anticipation of this. Summer Spring Township and this board has been let down and blindsided by FEMA. We wouldn't be here tonight if they hadn't hastily approved the insane plan to infill, sorry, I can't remember, to infill an existing this monstrous floodplain. Last winter, we were shown the map that I have here. Basically, it said 66%, I think was the number, percent of this land was in the floodplain and it couldn't be developed or nothing could be built there. And that's why we're here. But I don't think any of us ever expected this to happen, and we didn't expect FEMA would approve this. And anyway, we're here. We are here. For the record, as the crow flies, I live less than a mile from the Urlitz farm. I grew up here on a farm, and I know the local roads. My biggest concern is health and safety. My specific concerns, experiences, and observations are about traffic, but we have also have heard little about the air quality. Given our location in a valley between two mountains, reports frequently show the quality of the air here is, at frightening levels. The roads that surround the Urlitz property were constructed for the farming community. They've been the same as for 100 years. They transported milk trucks headed to market and tractors hauling hay wagons. In the 1950s, the CB School District added many dozens of school buses to the mix. Then came the major influx of fuel tankers from 2 tank farms. Let's also remember the rail line that crosses both Texaco and Hemp roads. Those trains carry dangerous fuel tanks and stop all traffic on those roads at least twice a day for 10 minutes. And I've timed them, and I know that if many times it goes beyond 10 minutes. But anyway, that's something we don't even think about, and we should think about. Just think about East Palestine, Ohio, and what happened there with their fuel tanks on trains. Because there has been little improvement to these roads, this proposed warehouse creates this recipe for disaster. Already traffic is stacked in all directions with no escape. Even emergency vehicles cannot get through. No traffic study shows what residents within a 1 to 2 mile radius already endure. There is no more room for additional traffic, especially 18-wheelers. We are attempting to put 20 pounds of potatoes into a 5-pound bag. Since October of 2023, there have been at least 44 reportable accidents on the roads near this site. My family experience is a small example of the dangers of the adjoining roads. On State Road alone, I personally have been involved in 2 accidents. My husband won, my daughter won, my grandson won, my granddaughter won. And we know better than most the horrific dangers of Texaco Road because we lost a daughter in a car accident on Texaco Road. There's no way that I can support this plan, and these people have done nothing to provide any kind of solutions for the traffic, and there are solutions, but the township cannot afford to provide them. Thank you.
Good job.
Supervisor Councilman or Liker, if you want to add anything.
I have a question, Sean. Attorney Clark stated that pertaining to the floodplain officer, is that a correct statement? Our manager had no authority to sign that?
Yeah, that's what I tried to address in that exchange, is I do not know the answer whether there was a specific delegation from Chelsea Levy to the township manager, but in the way the township staff is structured, he then steps into that role that would provide oversight to that department. So that's what the ordinance allows.
Would that oversight allow him to sign for that? Because he was saying it's pretty clear that it's either the building officer and in their absence,
Right. The ordinance says that it's the zoning officer or the delegate of the zoning officer. I'm paraphrasing this. So the zoning officer may delegate that to any other member of staff. 1. And 2, that's correct. In the absence of the zoning officer, it would be the department head of community planning.
all right, if that could be challenged and that's ruled to be void, how does that affect what would be approved? Because that would be an invalid signature.
I don't believe it would be an invalid signature. I don't think that would be overturned if it were before court, based on the ability of the zoning officer to delegate to anything on staff.
Okay.
All due respect, that's not what the ordinance says. Would you like me to read it?
I don't remember the specific section off the top of my head. Can you give me the section number?
It's the July 2023 change. Hold on. Section 4 of the 33-page amendment to the zoning ordinance from July 2023. The following shall be inserted by this amendment as the new subsections of section 219. And under 219, capital letter B, administration. Number 1, designation of the floodplain administrator. The zoning officer is hereby appointed to administer and enforce this section and is referred to herein as the floodplain administrator. The floodplain administrator may, and then it lists A, B, and C. A, fulfill the duties and responsibilities set forth in these regulations. B, and this is probably the relevant section, delegate duties and responsibilities set forth in these regulations to qualified technical personnel, plan examiners, inspectors, and other employees, or as later designated by resolution of the Board of Supervisors. And then or, capital letter C, enter into a written agreement or written contract with another agency or a private sector entity to administer specific provisions of these regulations, which I don't think is applicable.
Thank you.
So the question is the nature of the delegation and whether the township manager is technically qualified.
Right, and it was actually reviewed by HRG staff, which would be a technical advisor, and Aaron can address who, perhaps who specifically had reviewed it at HRG.
Can you ask that question again, Sean?
The Comar Act was reviewed by HRG specifically, right?
Yep.
Right.
Aaron, if you don't mind too, I'm sorry, could you just paraphrase what actually was signed? I think that would be helpful.
I don't know myself because we didn't sign it.
No, I know, it was, but you remember it was an acknowledgement of the submission, basically, the community, I can't remember the exact word that was used. Are you familiar with?
Yeah, I mean, I'm familiar with the document. We didn't, sign or review that document. All we did was review the technical information and address it.
Okay. Attorney Clark, would you be so kind to at least paraphrase?
Yeah, the form is called Community Acknowledgement Form. Capital letter A, requests involving the placement of fill. As the community official responsible for floodplain management, I hereby acknowledge that we have received and reviewed this letter of map revision based on fill. Based upon the community's review, we find the completed or proposed project meets or is designed to meet all of the community floodplain management requirements, et cetera, et cetera. Community official's name and title, Raymond Palmer, Township Manager, July 29, 2024.
So it's an acknowledgement of the Comar submittal is what it boils down to, not an endorsement of what is to be built there as much as an acknowledgement of the Comar, correct?
Qualified review.
Well, he's saying that this person says based upon the community's review. And I obviously have commented about what's that.
Community is defined as the governing body, or the governing authority, the township. And it was reviewed by the township engineer, which is HRG, and the township manager would have signed off based on that.
And we had expert testimony criticizing the Comar report that hasn't been properly responded to by HRG, and they had an opportunity to present an expert witness on the no-rise study, and they chose not to do that. So you didn't have an opportunity to ask about the Comar study.
Dave, I apologize if you cut in on your time.
No, I just think, to me, this is important right here. If they had someone sign something that was not authorized, that's what I'm trying to get down. Sean, your opinion is authorized?
The township manager is authorized because it doesn't say the floodplain administrator in that certification, and it's based on the review of the community. Again, community is the governing authority under those regulations, and it was reviewed by a member of your township engineering team, and the township manager signed off based on that basis. And based on that, said there was sufficient authority to sign off on that specific form for that specific purpose.
One other thing, these might be out of order, but we had a resident bring up about Mechanicsburg up in the northeast corner of our state. It's either upper or lower Mechanicsburg, between Silver Spring Township and one of the two Mechanicsburg townships. We have the honor of being number one in the state for I forget how many years for growth and development in our municipality. I think they're in the same boat we're in. You get into the path of, I call it resistance for development, and it's never a good thing. My family goes back over 100 years in this township. I can remember as a little kid, just a few years old. My grandparents had a farm out on State Road. My grandfather was neighbors with Nancy's dad. It was a simpler time. State Road was a lane and a half wide. They had an outhouse. They didn't have indoor plumbing. That's the 1970s. Not all that long ago. It was a lot simpler time. They were good neighbors too. My grandmother, and I've told Nancy this 1,000 times, you wouldn't have met anybody more critical of people than my grandmother. Her dad walked on water, Nancy's dad, because he'd come over when the snow got deep. My grandfather got to the point he wasn't in the best of health, and he always made sure that the driveway was plowed open. That was what this area was about, you know, neighbors helping neighbors. Also, people were accepting and they believed in the property owner's rights. That's been brought up tonight. Things have stayed the same until the 1980s. And I know a lot of people that are in here, and I'm not saying one way or another how I feel about this, but I know most of the people in here, the developments they talk about was open space when I was a kid. They live in Mulberry Crossings, Trindle Springs, Gingerfield, Brook Meadow, Stevens Drive, Evergreen, Walton, Rivendell. I heard all these developments brought up, all open space. Woods Drive was all one-lane bridges. A lot of people, as they moved in, I don't remember too many people that were residents of the township complaining about the new developments and the traffic it brought. I grew up on 114. I can remember rush hour. I could walk across the road, maybe have to wait 5-10 seconds, but you could walk across 114, and I'm sure a lot of people in here will find that hard to believe. It was easy access across the street to the development, Shady Acres. I had friends that lived over there, made many a trip across that road to go over there. I just want people to realize the traffic compounding that we have now, and I think 114 pushes up 15,000 cars a day, I think was the last I had heard. Just didn't happen with the plan that came in here today. It didn't happen with your plan. It's a magnification individually as they came to fruition and the developments were built. Along with Upper Allen Township, the development that we do have that happens in Monroe, and even northern York County, people come up to our area to do commerce, shopping, and the work. When I was a kid, we went down to either Lower Allen Township, or you went down to Lemoyne, or there was a little bit of shopping in Mechanicsburg Borough. I remember saying to people, you know, we live in Silver Spring Township, and they said, where's that? And that was the 1970s, and they were from Lower Allen Township. They didn't even know where Silver Spring Township was. A lot of people did not come to our township. But as time went on and the development occurred, especially the commercial, it became a destination. I just want people to keep that in mind. Whatever happens here happens. There's no malice on anybody's part sitting up here pertaining to what becomes of this. Things happen, and at one point in the 70s, Texaco Road was an industrial road. There was Bricker's Auction, there was Wayne Stevenson that had the machine shop. The Ryder Farm is the farm where Stevens Drive was, and up to where Mr. Simmons had his, I think it was turkeys there where Keener's office is. Then behind it, where Eichelberger was a seller's farm. There was not a lot in there. What was there was pretty much a commercial use other than those couple farms. And Mr. Ryder, when they sold out, that was piecemeal sold out. So I want people to know, one way or another, there was industrial there before the residential, and right, wrong, or indifferent, that's what happened. And the rail lines, well, I'm wrong, the Texaco truck plant was there for filling the trucks as well. This all came about, if you would have looked at a map, and I know that there was an aerial view, if you would have looked at it, it would have put you in mind of an area that was to be zoned industrial. I'm not saying one way or another, I just want people to think about this. Like, Mechanicsburg started building out, and we have conflict points, one of which was the area we're talking about now, and a lot of that was due to the rail there. The rail access makes things for people that do planning conducive for industrial uses. So, and I was quiet the whole time everybody talked. I'm giving people the things to think about when staff makes a decision and or that their approach to us with that they have to weigh things out as to what they're taught and what they have to work with there. And I'm not saying it was right, I'm not saying it was wrong. There was things that came into that decision that, you know, in hindsight, yes, there's probably going to be, if the plan would go through, points of conflict. The hard part is, and I'm sure that if the industrial was there first, we would still be dealing with that when the residential would be built. I just want people to keep that in mind. I'm not saying one way or another how I feel right now. But I will say, I've had a staff member tell me that they could find, and Scott, is it true that you've seen industrial zoning on that property in 1972? Ma'am, I didn't interrupt anybody when they spoke. I'm asking our staff member. I know there's people, there was an individual that said that I aired that was residential, that property. There was one corner of the Orlet farm on the southeast corner. I think it's approximately 15, 14 acres, which a lot of it is encompassed by floodplain, a popular term with this property, that in previous zoning, that was the only portion, I believe, that was classified residential, and what they did was they used the run as a physical barrier to do the zoning changeover. I just wanted people to understand that, because there was people that had said, yes, Scott?
So, just so everyone knows, I'm Scott Maldonado, lead land development specialist. There's a map labeled in our databases as 1972 that has some other changes, that there is some type of MR district, was a mercantile district where this location was. The map is hand-drawn and has some things on it, but there is a designation of MR in that general area.
So
I don't know what you're saying. I can't hear you. But I think this time is for the board, so I'm going to give it back to Dave.
Also, Scott, if it would have been left zoned at the light industrial, what permitted uses could be there?
I believe, if you're referring to the I-1 zone, I believe it was given during testimony that this same size building could be a manufacturing facility. There are numerous zoning requirements. I can read them off if you really want me to, but there's a ton of things that are in I-1.
But there, ma'am, can you please, there could have been uses that potentially could have made the same amount of noise or more.
Give or take. I mean, some of these are machine shops, manufacturing. Let's see, mini storage facility, offices, recycling facility by conditional use, drop lot, welding shop, medical marijuana dispensary. There's a bunch in here. So, but regardless, The size can still be the same, the use should just be different.
Okay, I wanted the crowd to hear, even if there would have been no zoning change, there could have been a use there that would be less than desirable to the neighborhood, and it would have been in place, it would have been by right as well for the most part. I just want people to have that in their mind, that regardless of how it would have been on our zoning ordinance, if there wouldn't have been that change, that it could have been some sort of use that generated a lot of noise, so.
Yeah, anything that's in that I-1 zone would be permitted either by right or by conditional use bounded by that district.
Okay. I know that there was another comment by someone that brought up about the shortage, the financial issue the school has and capacity issues. And we've asked about this as a board multiple times with residential development. We as a governing body cannot use that as a reason to deny a plan that is not a bona fide reason. So I want people to keep that in mind even for any future development. Our board's been kind of dealt a hand that's less than desirable. Since I've been on the board, I've been on the board since 2010. Nancy's the only supervisor up here that's been on longer. We've had a lot of plans that come through that people have been dissatisfied with. And a lot of the rezones or from agricultural had been done previously by previous boards. I think, you know, people had made the decisions. I don't think that it was done with any malice in mind. I think they did it, and there was plenty of capacity on the roads at the time. There was a lot of open space, and I don't think those people thought about how this would all play out when it filled in, you know, through development. So I think there's only been like maybe one property that we truly rezoned out of ag since, or one situation since I've been on the board that I can recall. So when people say, you know, oh, I've heard people say to me, you know, the board's done all this rezoning, they can stop it. We can't. A lot of the zoning that had been rezoned goes back even in the 1970s and 80s was done. And at that point, the people were either farming the ground or they were keeping it fallow for whatever reason. And what ends up happening as time goes on, the value of the ground gets more in demand. There's greater pressure for them to sell. I know the Yorlip family, from my understanding, this farm was in their family possession since the early 1950s. I don't think the family bought this with the intention of someday we're going to cash out, make a big profit off of this. It was bought with farming in mind. I talked to one of our largest farmers in the township. He's farming 3,000 acres. He flat out told me, if you're not farming 1,000 acres, you're not being profitable. The hard problem we run into in this area, a lot of the farming that's being done is on rented ground. As people have developments that are built because people need a place to live, the demand for farming ground becomes greater. They have more ground to be profitable, and it shrinks. So as people retire, there's no demand for farming. I just want all this to be kept in mind when people, you know, come to like whatever decision we make as a board, one way or another here. I want people to understand that all this stuff comes into play at the end of the day. I know a lot of the people that farm also face challenges moving their equipment on the road. A lot of them have had accidents because people will not, you know, either give them yield right away or they're impatient. So it presents challenges there as well too. It makes it harder for the individuals to farm. As far as the West Haven development, I totally do feel bad for the situation there. I know I spoke to the board, I spoke to the owner of that property previously, the board knows this happened. We tried to get him to come back in to have that changed to a small commercial lot subdivision because we realized that it was kind of in an awkward place for residential. The individual that owned that property at the time was in financial constraints. He chose not to do anything. He ended up losing the property. It went into investors. I reached out to them. They weren't interested in investing any money. They must have got the property at a good deal. They wanted to flip it, make money off of it, and chose not to do anything. And this was prior to our comp plan. If things would have been different at that point, we potentially could have done that. Change of the zoning there through that without needing to rely on the applicant, the property owner, applying for that, and we could have possibly prevented that issue. I do feel for the people that live on Texaco Road as well, because of the fact that I know what they deal with. I deal with it on 114, the traffic is unbearable. There's people up here on this board that are going to be impacted if this plan would go through in a negative way. Don't think, I know there was a comment from an individual that lived on Texaco last meeting that we don't care. I want everybody to know, I was in the hospital Thursday into the wee hours of Friday. I have a 7.6 millimeter kidney stone still in me, stuck. If I didn't care, I wouldn't be sitting up here right now. When people say things like that, it's disheartening without knowing the individuals that sit up here. So, I do have a question for our solicitor. The waiver, and actually I'll start with our engineer, Aaron. Condition number 5, the detention facility, the bottom elevation. If we wouldn't grant that, because I do have concerns with that. I mean, what's your feeling on that waiver? Because I've seen in the past where when your pond's lower than the floodplain, depending on the water table, depending on the year, those ponds do not drain. What's your feeling on that?
Yeah, it's a balancing act. If you would grant the waiver between the clay liner, keeping those waters out, and then the pumps getting the water that is in there from the warehouse out as well. So, if you wouldn't grant the waiver though, the applicant would need to redesign those basins. They would likely get shallower and wider to essentially keep the same volume, and they probably would not have to necessarily go with a pump system with all the redundancies built in. They would probably do a more traditional basin that just stores 100-year storm and discharges it.
Okay, what would happen what pops into my mind is the year we had the tornado come through, we lost a lot of electric. Is there an electric backup system for the warehouse that would power these, or how, if in the event of a power outage?
Yeah, I can't speak to whether the warehouse as a whole has that, but I do know one of the heavy suggestions that we presented to the applicant and that they agreed to do was include backup generators for the pumps on those basins.
Okay, so they did take that into account.
Correct.
And then this question would be for the solicitor. If there would be a motion to approve, at that stage, we have to have our conditions in line, right? If somebody's willing to make that motion, we would have to have our conditions predicated, or, the approval with associated conditions added.
Right, we would want that pulled together at that point, and to the extent they would need to be consented to by the applicant, we need to get that consent.
Okay, one other question. The traffic study that was provided by the applicant, if we, what mechanism, I guess the best way to put it is if we have doubts about something that was provided to us in a either testimony or a report, what mechanism do we have to get clarification, or is the only means we have is to vote for denial?
Right. Instead of saying doubts, I'd say if you have pointing to what you believe are deficiencies in the traffic study, you need to provide that input to the applicant, give the applicant an opportunity to answer those comments, either by perhaps revising the traffic study, or by citing specifically how they've addressed those concerns. And I know there's been a lot of both public comment, and I know the board has talked about the traffic realities on that road. I lived that and had some examples of what some of the public have commented, because I drive along there to get to my office here in the township, and so I understand that there are those concerns, but we need to be specific with the applicant to be able to give them a good faith opportunity to address those comments.
All right, then another point that I have, and it might be for other supervisors, if there was testimony maybe where we didn't feel we were qualified, I know Attorney Clark said we can discredit that. Is that something that we can, based upon the field of credibility?
Sure. Yes and no. So you have to look at the application in its totality, not just the testimony you had before you. The testimony you had before you really, as I described at the beginning of the public hearing, under 508, is an opportunity for public comment to be transcribed. That's what the hearing is for. What we did was we expanded that to have experts, both for the applicant and for the residents opposing the application, to have additional time than you would normally have under public comment. Bottom line, do you have the right to, the authority to determine credibility? Yes. You need to explain, obviously, why you would find those experts to lack credibility, one, and two, understanding that there are reports that have been provided that go beyond what that testimony was, so you would have to take those into consideration.
Okay. My question would be, Aaron, advocating for the township as the engineer, did you find anything in any point of testimony or anything provided to the township that you found to be concerning, or not something that maybe did not, you find applicable to any of the ordinances that you thought that they were outside?
Yeah, with regards to traffic or overall?
Any facet of any of their experts, either testimony or reports, did you find anything when you did your review to be inadequate or substantial?
Yes, so specific to the ordinances, the traffic expert and what I would call the floodplain expert didn't really provide much in the way of citations of ordinances, so I'd say no there. With regards to the third one, which is the most substantial one, they provided quite a few ordinance citations. I don't think any of them actually indicated objective non-compliance with the ordinance provisions. They may have some merit on A, some conditions that could be provided to you, or B, possibly anything with FEMA, but that's something to take up with FEMA. So no on ordinance provisions.
I'm talking as far as the applicant, though.
Oh, sorry, I misunderstood.
Yeah.
Yeah, I mean, initially there were. You'll notice we had quite a few review letters. And that isn't to say necessarily that they did a bad job. I'm not opining on that at all. I won't comment on the quality of their work. It's not something I can do. But regardless, as it stands now, there does not appear to be any substantial violations of the ordinances.
Okay, with the waiver that I questioned, waiver 5, do you have any concern with that, with the fact that they're pumping it? Is that alleviated? Here's your expert opinion.
Yeah, I mean, these systems are extremely rare in Pennsylvania. So I will say in other states where these are more common, it doesn't present normally an issue, and that the way that this has been designed is generally in conformance with how those other states do it. So I can't promise that nothing will happen. That's what the applicant can promise to you. But based on the criteria of other places, it doesn't seem to be out of line.
Okay. I know there was one last thing. I know the one resident, I agree with what they said about Stevens Drive coming out to Texaco, about the site distance. I think it is nominal there. And I want to bring that up to the individuals that are sitting in here now from Stevens Drive that we're advocating for a cul-de-sac. I don't really know if the gains are worth the losses of putting a cul-de-sac in there if this plan is approved, due to the fact at some point you might need to utilize that back access point onto Keener to get out to an area that is more conducive to see left and or right. So I just want to make that comment for people to think about. That's all I have.
Supervisor Cutsman, or anything to add?
Yeah, I would just like to comment on Supervisor Blanker when he said that there were a lot of farmlands around here. And I can remember back in the 60s, I guess that tells my age, there was a lot of farmland because I used to hunt on farmland. So Silver Spring Township has really taken off. I thought about what the lady was talking about, like the Continuance, the Bible verse, time to be silent and time to speak. And someone asked me a question about warehouses. And I guess my answer to them is, well, I am not in favor of this or any other warehouse that meets all ordinance requirements when there are other options available. And listening to some of the residents talking and reading a lot of emails, I sat down and I wrote out some things that expresses the way I feel. While we seem counterintuitive to object to a warehouse that complies with all local ordinances and regulations, there are several substantial reasons why such an objection can be both valid and necessary. Quality of life was mentioned, impact on the local character and aesthetics. Warehouse by their nature are designed for functionality rather than beauty. Introducing such a building can disrupt neighborhood, architectural harmony, and visual appeal, leading to a diminished sense of place and identity. And the other thing that was really mentioned was environmental concerns. And I wrote out, although a warehouse may meet all environmental regulations, this does not necessarily mean it is environmentally benign. Construction and operation of a large warehouse contribute to increased air and noise pollution, with heavy-duty trucks frequently traveling to and from to and from the site. And as Supervisor The other thing is warehouses often require significant vehicle activity, including large trucks and delivery vehicles. Even if traffic studies suggest that the existing road infrastructure can absorb this increase, the lived reality can be markedly different. Okay. Residents may experience heightened traffic congestion leading to longer commute times and increased frustration. That was also mentioned tonight, that you pull out on Texaco Road and you have all these trucks trying to turn on 114. So that can cause a lot of frustration. The other one is that I was thinking a lot about was safety risk. The influx of large trucks presents safety risk. In residential areas can be included for that, where children play and pedestrians walk. If you don't have sidewalks and you're walking with your children out in the street, and sometimes people aren't watching the trucks, can be difficult to maneuver. The economic part of it is the presence of a warehouse can chill local property values, and that was also mentioned by some of the residents. Community well-being. It was also mentioned about mental health considerations, noise pollution, increased traffic in declining neighborhoods, aesthetics, and contribute to stress and anxiety. Furthermore, the potential loss of green space is often sacrificed by industrial development, deprives residential of natural environments to promote well-being. And I guess my conclusion is, while warehouse may meet all the ordinance requirements, the broader implications for the community and individual residents must be carefully considered. From environmental and safety concerns to economic and social impacts, the presence of warehouses can be significantly alter the quality of life in neighborhoods. Years ago, a lot of these roads were dirt roads. They didn't have a lot of truck traffic on them and everything. And I talk to Aaron all the time about these roads and the impact that the roads have on the township. So some commerce is good and some is not good. And I'm not really in favor of any warehouses. And I deal with the New Kingston Vision. And I know there's always, I always get complaints about, oh, this truck was here and this truck was there and stuff. And they're supposed to turn down Farmer Street instead of Locust. And when someone's driving a truck, they always look for the shortest route to go. And wherever that might be, it's really not good for the residents and stuff. So even though it meets the ordinance, I'm not really in favor of having warehouses.
Woo!
Thanks, Harry. I also have a statement. I think if you'd allow me, it'll make my position clear as well. The plan before us is exceedingly above and beyond what was ever contemplated during the comprehensive planning meetings. I feel frustrated by the developer's lack of willingness to present realistic conditions in a timely fashion. Furthering my frustration is the feeling of being held hostage by these conditions, as potential funding for improvements is quickly eroded by several clauses in the offer, and infrastructure liabilities are punted to the township to implement at an unknown future time. I believe the developer also has a duty, as was described, that the board has to act in good faith. I received the last set of conditions on my drive over here this evening. It's incredibly unfortunate that our community has had to resort, allow me to start over. I don't believe the developer has taken resident concerns seriously, having only met with them on one or two occasions. It's incredibly unfortunate that our community has had to resort to the extent that they did in hiring attorneys and engineers to try to drive their points home. And we as a board owe you an apology for allowing that scenario to unfold. Also, owing you an apology is the landowner who could have still met the personal, financial, and land use goals in many other ways without completely selling out their community and their neighbors. Because you can does not mean you should. There's growth in the community, and there's also doing right by your neighbors. This is a mistake. It does not belong in the center of our township on rural roads, and it too greatly jeopardizes the safety and well-being of our communities. I would be remiss to not acknowledge our staff, as well as our attorney and engineering team's time, efforts, and stress that has been caused by this plan. Thank you for seeing it through with so much pressure to get it right. I'm still hopeful that a solution is forthcoming, but for the reasons I've mentioned, as well as the concerns articulated by my fellow board members, I'm a no on this plan. Okay, so we know where the board stands. We're basically to the point of a motion this evening. Look for a motion if there's one to be put on the table.
I make a motion to deny this plan's approval.
We have a motion to deny from Supervisor Brown. Is there a second?
Second.
Supervisor Griffey, second. I'd ask Willetta to call the roll, please.
For your adopted rules of order, the roll call vote will be taken in alphabetical order. For the motion,
No,
Just to clarify.
I'm denying.
So, yes to deny.
Yes to deny.
Yeah, let's clarify that, because it was a motion to deny, an affirmative vote is to deny. Okay, so, yeah, I'm going to give Willetta the microphone too. So.
You are denying.
Yes, that is correct.
Supervisor Griffin.
Denying.
Supervisor Kotzmoyer. Supervisor Lenker.
I vote to deny.
And
Woo!
Chair Mohammed.
Vote to deny.
Township subdivision land development ordinance, based on the denial, the Township Board of Supervisors will provide in writing, specifically cite any conditions of approval, not with facts or defects, which is what we will need to cite, to be communicated to the applicant personally or mailed to them, last known address no later than 15 days following the decision. That would be October 24th, which is one day after the next board meeting. That is all I have. Chairman Bachman.
Thank you. That would likely conclude this evening. If there's nothing else to come before the board, I look for a motion to adjourn. We have a motion to adjourn. Is there a second?